Hi Tradelab, we are Roni, Shai, Yasmin, and Iris of the International Trade and Investment Clinic from the Hebrew University of Jerusalem. Our project is about deep sea mining and indigenous coastal communities. Our beneficiary is the Society for Threatened Peoples, an international human rights organization that advocates for threatened indigenous peoples. In our work, we hope to provide guidance on the legal tools available to help indigenous communities deal with the effects of deep sea mining in territorial waters. First, let's start with a brief explanation about deep sea mining, or DSM. DSM is the mining of metals found on the seafloor using different techniques. These metals can be used for the production of different products, such as batteries and cell phones, and are generally viewed as a possible alternative energy source to fossil fuels. In our work, we focused on the mining of manganese nodules using remote-controlled tractor-like devices. Because such mining has never been carried out, only its exploration, the full environmental and social implications aren't yet known. However, scientists estimate that the damage to the environment and ecosystems may be severe. The main known effects are environmental and social. Mining in the deep sea may have a detrimental effect on the deep sea environment and the organisms that thrive there and develop over hundreds of years, and whose recovery from DSM could take just as long. The social effects are both on the livelihood of the indigenous communities and their access to culturally important sea routes and traditions. For example, the indigenous community of Papua New Guinea perform a religious rite called shark calling, a seasonal hunting ritual in which sharks are called through large seashells. The ritual could be disrupted because sharks cannot hear the calls over DSM machinery. The main legal issue we address is the protection afforded to indigenous peoples in limiting the right of sovereign states to exploit their natural resources. Our work plan is to split and review the 4 areas most relevant to this question in international law: environmental law, maritime law, indigenous peoples' rights, and investment law. Our research into these areas of law was extensive and included many hours of reading conventions, rules, and articles, and zooming into the little hours of the night. In the context of environmental law, we tried to understand whether the general principles and treaties require the states to prevent damages that are not known under the precautionary approach. We have also tried to ascertain the status and scope of the right to a safe environment under international human rights law, and whether the indigenous peoples can enjoy such protection under the human rights legal regime. In our chapter on maritime law, we examined what laws apply to the coastal state by the Convention of the Seas. While the treaty allows states to exploit the natural resources available to them in their territory, they are obligated to preserve the maritime environment under their control, partly via domestic regulation and legislation. The Convention requires that these laws be no less effective than the international standard, which we studied through countless conventions, agreements, opinions, and articles in order to understand. We have also found that the Convention should be interpreted in light of the human rights regime, and, therefore, the right to utilize natural resources may be limited in order to comply with human rights standards. In the context of indigenous peoples' rights, we reviewed the different rights and the state's obligations towards them. We delved into the indigenous peoples' rights to free and prior informed consent for activities that may harm them in some way, a right largely upheld by courts. However, we have found that this right does not invoke a veto right, especially in countries where the majority of the population is indigenous, at least not regarding deep-sea mining. When researching investment law, we tried to look at how the state can protect itself from the claims of international investment when limiting deep-sea mining projects. We explored bilateral investment protection agreements and their existing exceptions, including the environmental and public morality exception. We also tried to understand whether and to what extent a state can make use of these exceptions when it harms investors by eliminating deep-sea mining projects. In conclusion, deep-sea mining has not yet been carried out, so its full effects are not yet known. For this reason, the legal situation is still unclear. After our legal research, we believe that the legal tools available to coastal indigenous communities are limited. However, we have introduced theoretical tools to combat this mining and to mitigate its negative effects.